And with me now is Ian Lee, Associate Professor at the Sprott School of Business at Carleton University. Ian, welcome. So let's start off with this. Are there going to be any legal implications for the union's decision?
I believe there will be. I do want to caution you, I'm not a labor relations scholar, but I did when I did my PhD thesis on Canada Post, the final third of my thesis was focused on all of the back-to-work legislation occurred in the 60s, 70s, 80s, 90s. And so I ended up studying the labor relations of federal crown corporations and federally regulated industries very, very deeply and extensively. Renee, this is going to, I believe, be momentous from a legal and a public policy point of view. The Supreme Court ruled in 2015 that workers have the right to strike under the Charter of Rights. This was in response to a Saskatchewan law that tried to strike down the right to strike in the public sector of Saskatchewan. But the Supreme Court also ruled that it did not governments could still designate services as essential, such as national police, RCMP, the military, the border, people in prisons, the workers, the correctional service people. And so what the government has done is ordered the people, the striking flight attendants back to work, but they are correct in stating, the union Cup W is correct in stating it is on the surface illegal because they're not designated essential workers. They do have the right to strike according to the Supreme Court, and there is no apparent emergency. It's unbelievably inconvenient. I'm a good example. I'm stuck in Vancouver trying to get home to Ottawa. But that I'm not sure that the court will rule that extends sufficiently to justify the order. So we may see the court striking down the order by the government of Canada.
Could that impact the federal government in its decisions to step into strikes like this?
Absolutely important question. I did a paper called Striking Out about 15 years ago. I updated it last year, and I went and looked at all of the back-to-work legislation adopted or proposed in the government of Canada, in the Parliament of Canada, from 1950 up until last year. 44 times successive governments of Canada, Liberal and Conservative governments, have issued back-to-work legislation, or in the last 5 years, they've been using directives through the CIRB, and this hasn't been fully tested. And so the question is, will the court, and it probably will get appealed to the Supreme Court of Canada, will they support a directive like this where there is clearly massive inconvenience and massive dislocation to the workers and people and businesses of Canada, or does that constitute the right, does that grant the authority to the government to intervene? And so this is going to be a momentous decision. I'm certain it's going to get appealed to the Supreme Court, and then it's going to force the government to address this question of should they be designating railroads, ports, airlines as essential services.
Right. Ian, I wish we could chat for longer, but we're going to have to leave it there. Ian Lee, Associate Professor at the Sprott School of Business at Carleton University. Thanks for being here with us.
Thank you, Renee. Thank you.